Good morning to everyone. It's 10 o'clock and let's respect the time of everyone. Dear sir and madam, ladies and gentlemen, honorary speakers, your excellence, I have a great pleasure to open this event, which is a Jean Monnet conference entitled Intellectual Property Development in the European Union and Republic of Moldova, Challenges and Perspectives. And I want to welcome you to this wonderful conference that is organized by the Association of Legal Culture Henri Capiton in Moldova in collaboration with State Agency of Intellectual Property of the Republic of Moldova, as well as the Embassy of France and Alliance Française in Republic of Moldova. Before proceeding to put into
Me cierra la cortina y me da la luz.
Before proceeding, I just wanted to mention you briefly that this conference is organized within the framework of the project Jean Monnet Support to Association, European Integration and Intellectual Property Protection Studies, which has a short title, EUPROIN, which is implemented by the Association of Legal Culture Henri Capiton Moldova with the support of the Erasmus Plus program of the European Union. Let me introduce myself. My name is Rodica Crudu. I am a PhD associate professor at the Academy of Economic Studies of Moldova. But in this event, I do represent the Association of Legal Culture Henri Capiton Moldova, within which I do have the honor to be the director of program and projects. Besides this, I'm very honorable to have the title of Jean Monnet Professor, coordinating several projects in European integration studies since 2014. Besides that, I am a Fulbright alumni and I'm very proud of this, having opportunity to benefit of a Fulbright fellowship in 2017-2018 at the American University, Washington, D.C. The purpose of the conference is to strengthen the understanding and awareness of research on the topics related to intellectual property, not only in the European Union, but beyond this. As you can see from the program, we do have a lot of speakers out, not only from the European Union, but also outside Switzerland, UK, Ukraine, Belarus, and so on and so forth. And I use this opportunity to thank everyone for accepting our invitation and contributing to the success of this conference. The other objective of the conference is to increase the visibility of research on issues related to intellectual property protection, to inform and sensitize the representative of civil society, as well as civil servants, on the importance of the intellectual property development for the Moldova's integration and its economic growth, but also to analyze the main achievements and problems related to IP development, but also its interference with the other sectors, for example, competition, creative industries, and other spheres. As you can see from the program, the debates where the discussions within this conference will be organized into the 3 panels, each of them specializing or focusing on a specific subject. For example, the first panel is intellectual property and competition and interferences between the 2 fields. The second one is intellectual property in support of creative industries. And the third one, it's kind of broader one, focuses on European integration and intellectual property protection. Once again, I use this opportunity to thank in advance everyone for fruitful debates and discussions, for accepting our invitation, and let us wish us all a fruitful conference. Now I want to give the floor to Mr. Dorin Chimil, which is the president of the Association of Juridical Culture Henri Capiton, Republic of Moldova, but also is a key expert in the EUPROIN project, under the framework of which this conference is organized.
Thank you very much for my introduction, Rodica.
Welcome.
The Henri Patent Association was founded in 1935 by a group of lawyers from different French-speaking countries, Belgium, Luxembourg, Quebec, Switzerland, etc., and under the authority of Henri Patent, professor of the Faculty of Law in Paris. The official name is Association des Juristes de langue française, Association of French-speaking lawyers. The association brings together a large number of law professors, magistrates, lawyers, and number of various legal professions. Till present, the association has development intellectual tied with foreign groups from more than 15 countries, Moldova being one of the links of international network of French law traditions. The association Henri Capiton from Moldova, even it was recently founded by 10 January 2019, has as the main objective the establishment of periodic professional relations between lawyers attached to the European law culture and in particular to the French legal culture. They offer expertise in legislative activities and in organization of scientific training conference conducted both at national and international level. L'association Henri Capiton fut fondée en 1935 sous l'autorité d'Henri Capiton, professeur à la faculté de droit de Paris, par un groupe de juristes de différents pays de langue française, Belgique, Luxembourg, Québec, Suisse, etc., sous le nom d'Association des juristes de langue française. L'association rassemble un grand nombre de professeurs de droit, magistrats, avocats et membres de différentes actions juridiques. À ce jour, il y a tissé des liens intellectuels avec des groupes étrangers de plus de pays, la Moldavie étant l'un des liens du réseau international des traditions du droit français. L'association Henri Capiton de Moldavie fut récemment créée 10 janvier 1919 et son objectif principal est d'établir des relations professionnelles régulières entre les juristes attachés à la culture des droits européens et en particulier à la culture juridique française. Il offre expertise dans l'activité législative et dans l'organisation des formations, conférences scientifiques au niveau national et international. Merci beaucoup.
Thank you and merci beaucoup, Monsieur Jimin. Thank you for supporting us in implementing this project as one. Now I want to give the floor to our official partner implementing the EUPROIN MONNET project, which is a state agency for intellectual property of the Republic of Moldova, which is in this event represented by the General Deputy Director, Mrs. Mogol Natalia, which is also part of the team of the implementation of this project. Mrs. Mogol, please, the floor is yours.
Thank you, dear Rodica. Dear ladies and gentlemen, participants of the Jean Monnet Conference dedicated to intellectual property, I am very pleased to greet you all on behalf of the State Agency on Intellectual Property and of the Director General, Mr. Viorel Justin. First of all, I would like to express my sincere thanks for the invitation to come with a greeting message during this event dedicated to an extremely current topic in today's conditions, intellectual property. I am glad that despite the coronavirus pandemic, the organizers have found a solution for this event to take place. IGP has a fruitful collaboration with the EUPROIN project, organizing together several similar events which have proven to be successful and in which many current issues in the field of intellectual property have been addressed. As you well know, IGP is the institution that emphasizes the stimulation of creativity, innovative spirit, and curiosity in discovering innovative solutions. And the EU PROIN platform is conducive to finding the best solutions to promote knowledge in the field of intellectual property, but also to find solutions to existing problems in the field. In the context of the above, I reiterate the openness of the State Agency on Intellectual Property to provide support to any academic, but also for non-academic initiatives aimed at raising awareness of the importance of the intellectual property for sustainable economic development. I want to express my confidence that this event will give participants the opportunity to address current intellectual property issues, to ask questions, and to identify, I hope so, certain solutions. Dear participants, on behalf of the State Agency on Intellectual Property of the Republic of Moldova, I wish you a very successful conference and enjoy.
Thank you, Natalia. Thank you, Mrs. Mogor. In the implementation of the project, we do have two other partners that I've mentioned. This is French Embassy in the Republic of Moldova and Alliance Française. And now I want to give the floor to Mr. Chavon Alexandre, which does represent the Alliance Française de Moldavie in Republic of Moldova. Mr. Chavon.
Thank you very much. Good morning, everyone. I have been told I could express myself in French, so I will do. That will be clearer for me.
For our English-speaking speakers, I will translate afterwards your speech.
Thank you very much, Madame Crudo. Bonjour à toutes et tous. Merci beaucoup, Madame Crudo. Et merci à Madame Olesa Plotnik aussi et à tous pour son et votre invitation à la conférence Jean Monnet autour du développement de la propriété intellectuelle en Union européenne et en République de Moldavie. Alors, quelques mots simplement. Alexandre Chavan, je suis chargé de mission éducative ici en Moldavie à la suite de Monsieur Giovanni Cavallaro. Je salue tout d'abord Madame la coordinatrice du projet, Monsieur le président de l'association et Madame le directeur général pour leur présentation et introduction de cette journée si particulière. Aussi, je me permets donc de représenter et d'associer à cette prolifique réunion, et j'en suis sûr, au vu des personnalités et thématiques annoncées, l'ambassade de France en République de Moldavie et son opérateur, l'Alliance française en Moldavie, finançant conjointement le projet. Comme vous le savez, la poursuite de ce projet EU PROIN au sein de l'Université d'État de Moldavie et tout spécialement de cette filière universitaire francophone tient on ne peut plus à cœur au poste dans le pays. Aussi, je me permets de saluer tout particulièrement les efforts des acteurs de l'association Henri Capitan de culture juridique française, promouvant, comme évoqué avant moi, la culture du droit européen et dont le groupe moldave depuis 2019 s'attache à renforcer la capacité institutionnelle de l'Agence d'État pour la propriété intellectuelle. Merci également et encore à Olesa Plotnik pour son investissement sans borne et tout personnel dans le cadre de ce projet. Merci à tous et excellente, fructueuse journée de conférence.
Merci beaucoup, Mrs. Chavon. Let me briefly translate the main message of Mr. Chavon. He's greeting everyone. His name is Alexandre Chavon, and he's responsible for the education mission in Moldova, following Mr. Giovanni Cavallaro. Okay, first he started to greet everyone in the plenary session, but also all the participants and attendees to this event. In this prolific meeting, Mr. Chavon represents the Embassy of France in the Republic of Moldova and its partner, Alliance Française de Moldavie, which contributes to the co-funding of our project. Mr. Chavon also mentioned about the importance of the continuation of the EUPROIN project within French-speaking universities branches in all universities in Republic of Moldova. Also, he took the opportunity to greet in particular the efforts of the member of the French Association of Legal Culture, Henri Capitan Association, to promote the European law, and of which the Moldovan group, I mean, our association since 2019 has been working to strengthen the institutional capacity in collaboration with State Agency for Intellectual Property. He was also thanking Mrs. particularly Olesia Plotnik for her boundless investments and all personnel within the framework of this project. And at the end, thanked in advance and wished us all a successful conference. Thank you, Mr. Chavan. Thank you very much for your support in implementing our project.
Vă mulțumesc frumos, doamna Crudu.
This is before proceeding to our plenary session, because I was talking a lot about our project. I just wanted to briefly tell you a few things about the project, not too much, because I'll tell you at the end where you can find more information. So our project is called Jean Monnet Support to Association in European Integration and Intellectual Property Protection Studies. And it is implemented with the support of Erasmus Plus program of the European Union. The main objective of our project, as you can see from this slide, is to raise the awareness and the importance of intellectual property rights towards the progress of a legitimate economy, Republic of Moldova, progress towards an area of shared prosperity, good neighbor lines between the EU and Republic of Moldova. But also another goal is to disseminate tailor-made information about new framework of IPR protection to a wider public, also in EU, but also in Republic of Moldova. To increase cooperation between different stakeholders in Moldova on intellectual property rights protection, and to strengthen the cooperation for a more prosperous and sustainable European economy. Another goal is to have a more efficient delivery of public services through fostering the dialogue between the academic world and policymakers and addressing skills gaps among actors in the country. To enhance the visibility of scientific resources and research results in the field of IPR protection studies in Moldova. And not only, and this event is one of the opportunities for all researchers to share their knowledge and the result of their research, but also to improve the understanding between in EU and all countries, or all countries that are represented today in the conference, of the actual development problems and those trends on IPR protection, both in EU and Republic of Moldova. A few things about the activities that we plan to implement in EUPROIN project. We do organize one conference a year, and I have to tell you that this is the second issue of the conference we do organize, and we are very pleased to have a great interest in the topic of intellectual property protection, and particularly in European integration. We do organize each year a round table, but it happened because of the pandemics to organize a webinar dedicated to the celebration of Intellectual Property Day. We have organized already 3 youth seminars in not in Chisinau, the one being organized in Balt in the north of the country, the other in the south of the country in Cahul, and the last one, which was organized on this Tuesday in Tiraspol in the left bank of Dniester River. We plan to organize also 3 workshops for business environment. Informing businessmen about the importance and how they have to look to the IPR protection, but also with our team, we plan to work to do research on 2 main topics, which are mainly focused on the interrelation between the intellectual property rights and competition law, as well as consumer protection and intellectual property protection. As you can see from the events that we plan to organize, our target audience is youth and business environment, but also academia, research staff, and civil society. The project started to be implemented last year in November 2 years ago almost, yeah. The time flies so fast. In November 2019, and is planned to end in November 22. Till the moment, we are on target with implementing all the activities planned within the project, and that's because of the technologies, information technologies that allows us to organize all the planned events. These projects could not happen and could not be implemented and does not have any chance of achieving all the results planned, all the outcomes and deliverables without a strong team. And I'm really happy and honorable to present my team, which is the project that is led by me, is managed by me, by myself. But I do have really wonderful people that we do collaborate very successfully. This is Mrs. Olesa Plotnik, which is a key expert in the project, but also General Secretary of the Association Henri Capital in Moldova. Then you have already the opportunity to meet Mr. Dorin Cimil, which is the president of the association, but also key expert in the implementation of the project. Then we have Natalia Mogol, which is a key expert in the project, but also representing a state agency for intellectual property protection in the Republic of Moldova, and Mrs. Elena Jokin, which is the assistant of the project. As I mentioned to you before, in the implementation of this project, we are happy to have as partners the State Agency of Intellectual Property in Republic of Moldova, Alliance Française, and French Embassy, which are also co-financing our project. I will not stop too much. I will just let you all the details how you can follow us and keep in touch with us. So you can visit our webpage, which is yauprint.md, or contact us by email. You have already received a lot of emails, I guess, from Henri capitanmd.gmail@gmail.com, but also we do have another email that is specifically for the project. And because social media platforms currently lead everything, and this is the place where we define a lot of our participants and our target audience. We are on Facebook as well, with the short title henri.capitan.md, or with the long title Asociația de Cultură Juridică Henri Capitan Moldova. This is in fact what I wanted to tell you about the project. Now we are proceeding with the plenary session of our conference, and I'm really happy and proud to open the plenary session with His Excellence, Mr. G. Robles Jose Maria, which is Honorary President of European International Movement and Honorary President of Euro-Mediterranean University. It was the 19th President of the European Parliament, from in the period of 1997 to 1999, but also a former member of European Parliament in the European People's Party group. Your Excellence, thank you once again for accepting our invitation. Thank you for dedicating your time to share your experience and knowledge, and welcome all the participants to our conference. Your Excellency, the floor is yours.
It's myself which thanks you very much for this invitation and this opportunity to speak to the friends of Moldova on the question. I thank you very much for these welcome words, and I will say just some things about, some ideas about our subject, especially our subject. Well, European Union has shaped a framework that defines and protects innovation and creations through intellectual property. This framework mainly comprises the directives and regulation protecting copyright, trademarks, patents, designs, and geographical indications. It's really now an enormous economic framework. These industries account directly for 27.6% of all the jobs in the European Union, about 56 million of direct jobs, and 39% of total economic activity in the Union, about 4.7 or 5.0 million trillion. Well, intellectual property rights are protected mainly through these different figures that I will just go on. The copyright. Copyright employs over 11 million people in the United Europe, 5.4% of all European employment, and contributes around 914 billion to the European economy, or more or less 6.8% of the European Union gross product. Copyright is, as you very well know, the right that creators have of the use of their literary and artistic work. Normally, it is in the territory of a specific state. However, the European Union provides a secure environment for cross-border trade in copyright-protected goods and services, and facilitates the development of electronic commerce. Well, a very special and very successful part of that is the geographical indications of origin. It's something which is proper of European Union. Geographical indications are signs used on goods that have a specific geographical origin, possess qualities, reputation, or characteristics that are essentially attributable to that place of origin. Champagne or prosciutto di Parma are well-known examples of agricultural geographical indications of origin. Spanish are always fighting for jamón as an indication of origin, which not only is excellent as food, but rarely has specific properties. Well, there's a continuous fight because in many other parts of the world, the same or similar products are produced and want to benefit of these names as if they were names of a quality of aliments of and really they don't have. They are aliments which are produced in very specific parts of the territory, and we are always fighting for that. But in fact, that continuous fighting has been successful for Union, and more geographic indications of origin are admitted. The patent gives the owner the right to prevent others from making, using, or selling the invention without permission. Technical invention, therefore, can be protected in Europe either by national patents granted by the competent national authorities or by European patents granted by the European Patent Office. In effect, that one is being expanded by the simple reason that patents granted by the European Patent Office are much cheaper in the whole than having a complete series or sets of national patents. It has been calculated that the valuation cost for obtaining patent protection in 37 member states would amount to £32,000, meaning around 193 million per year for the entire European Union. With unitary European Union patent, these fees could be reduced to an average of 5,710, giving a net gain of more than £26,000 for each year patenting filing. A trademark is a name, word, phrase, or logo used to make it clear that product or service originates from a unique source. To make it easier and cheaper for businesses operating in the internal market to register their trademark, the community trademark was established in 1993. It was the first move. The European Union trademark replaced the community trademark in 2016 and provides uniform protection throughout the European Union, which can be obtained by means of a single procedure and filed one only in any European Union language. It gives the owner an exclusive right in all the member states for 10 years. The European Union trademark significantly reduces registration fees. Businesses now pay £115 to register online on European Union trademark instead of the previous fee of £1,750. Designs. A community design is an industrial designing machinery, tools, electronic equipment, right, that covers the European Union. It has both unregistered and registered firms. The unregistered community design came into effect on 6 March 2002, and the registered community design is available since 1st April 2003. National registration systems still coexist. Community designs and EU trademarks are registered in the European Union Intellectual Property Office, EUIPO. The introduction of a community design allowed regressive registration fees. A design registered separately in all member states will cost at least £2,695 compared to 350 at EUIPO. Integration and cost, transactional costs, and registration filing. Well, the European Union has fostered measures to protect international property rights. Many challenges remain. In the copyright area, the review of the EU copyright framework assessed that the European Union copyright regime is still fragmented. It underlined that the European Union today is still characterized by 28 different copyright systems, and that the implementation scope of exceptions and limitations in member states vary significantly. It underlines inter alia that these fragmentations harms commercial users and copyright works, online intermediaries, and end users, recommend further harmonization. In addition, is there no currently European Union-wide protection for non-agricultural words in the question of the geographical indications of origin. European Parliament, in a study which was done the 6th October 2015, and a study conducted by the European Commission, considered that there is a case for harmonization for the creation of a new necessary title of protection for non-agricultural geographical indication products across the European Union. Let us hope that we succeed to obtain that in not too many years, but it still needs a lot of efforts. In the emergence of new models and consumption patterns, increasingly characterized by the use of the internet, has a significant impact on users and creative industries, and represent a challenge to copyright protection within the internet market. Available data showed that a fully integrated digital single market, including international property dimension, could contribute between 2,060 billion and 520 billion of euros to European gross development product. The long-term growth impact of the digital reform already undertaking is estimated at above 1%, and further efforts in line with the digital agenda European targets are expected to generate additional 2% of gross development product efforts. That's to say that we are in full digital revolution or evolution, as you must prefer to say. In fact, the European Commission presented a legislative package for the modernization of the European Union copyright rules, including a new directive on copyright in a digital single market, which was the most attracting attention. On 14 September 2016, that's just yesterday, stakeholders and academics were strongly divided in the proposal, as we could suppose. In February 2019, after more of 2 years of protracted negotiations, the co-legislators agreed on a new set of copyright rules, including 2 controversial provisions. First, creation of a new right that will allow press publishers to claim remuneration for the online use of a new publication, Article 50, a provision that, of course, big companies don't enjoy at all, and allow press publishers to claim remuneration for the online use of their publication, Article 15. And point to the imposition of content monitoring measures on online platforms such as YouTube, which seeks to resolve the value gap and help rights holders to better monetize and control the distribution of their content online. Furthermore, in addition to the mandatory exception for text and data mining for research purposes proposed by the Commission, in its proposal, the co-legislators agreed to enshrine in European Union law another mandatory exception for general text and data mining, Article 4. In order to contribute to the development of data analytics and artificial intelligence, the European Parliament in plenary and Council approved the compromise text in March 2009 and in April 2009, respectively. The directive was published on 15 May 2009 in the official journal of the European Union, and all member states must transpose the new rules in the national law in June 2001. That means that we are just in the middle of the most strong battle of the last times to see the limits of the intellectual property. In any case, let me say that we can foresee that in some years waters will be surely more calm than precisely in these years, and less controversial regulation for copyright in the digital single market will arrive. Thank you for your attention.
Your Excellence, thank you very much for this welcome message, but on the other hand, very comprehensive message that was relating to EU efforts to strengthen the intellectual property protection, mentioning that even though currently this environment or the regulation is very complex, is still fragmented and needs harmonization, and its outstanding efforts to tackle those challenges EU faces in regard to ensuring IPR rules and IPR rights protection, especially in the digital era and in the online environment. Thank you once again, Your Excellence, for this insightful welcome message. Thank you very much.
Thank you.
Now I want to give the floor to Professor Heinemann Andreas, which is a professor at the Faculty of Law, Chair of Commercial Economic and European Law, University of Zurich, but also is a member of Swiss Competition Commission. The reason and the rationale of inviting Professor Heinemann for the plenary session is that we are going to have a specialized panel on the issues related to the interference between the competition and intellectual property protection. So I do believe that the message of Professor Heinemann will give a best introduction and motivation for all the attendees to attend this panel. Professor Heinemann, the floor is yours.
Thank you very much, Professor Krudu, for having me. I'm really happy to be here and to assist at this conference. And thank you also to the whole project EU ProIN. Et je remercie également l'association Henri Capitan en Moldavie pour l'invitation. I'd like to share my slides with you. Just put it up. And as Professor Krudu already explained, I want to present a topic at the interface of intellectual property protection and competition law. And there is a lot of problems at this interface, because intellectual property is embedded in the entirety of the economic system of a country or of a jurisdiction. And so it is important to determine the way intellectual property interferes with the rest of the legal order. And the topic I have chosen is the topic of patent strategies, which is a very important topic for the reality of the firms, of the innovative firms, of firms who do research. And I'd like to share some thoughts about that topic with you. The starting point is what Professor Krudu already mentioned, the relationship between intellectual property protection and competition law. I take the example of patent protection. And there we have a complete shift in the perception of this relationship, because in former times, a conflict between patent protection and competition law was supposed. The perception was that patents grant monopolies and competition law is against monopolies. So there was a clash between the two fields, and it was necessary to provide for precise rules on the relationship between these two fields. And some said patents should always prevail and competition law would have to step back. And others said, no, competition law is much more important and patents have to step back if there is a conflict. This view is has been overcome because since the 1970s, both fields, IP and competition law, are perceived not as conflicting anymore, but as complementary. Why that? Because now we look rather at the goals of these two fields. And the goal of patent law is to promote innovation by granting exclusive rights. And competition law protects the competitive process, which should also generate innovation. So both fields of law share the same goal. They go into the same direction. They want to promote innovation. And so there is no conflict anymore, but both fields want to do the same thing. The consequence is that today we would say that the use of patents is normally compatible with competition law. Also, the strategic use of patents. It's completely legitimate to use patents in a strategical way. But there may be exceptions. There may be single cases where the strategic use of patents may create a conflict with competition law. And to determine these fields where there may be a contradiction, we have to distinguish between defensive patent strategies and offensive patent strategies. In defensive strategies, patents are filed to ensure that one's own innovations can be used. And in offensive strategies, patents are filed to impede the innovations of competitors. So this is a completely different use of patents, because defensive patent strategies seem to be completely legitimate, because this is the goal of patent protection, to create incentives for more innovation, for more inventions. And it's the very goal of patents to protect the inventors, so to defend their innovation. This is a legitimate use of patents. Offensive strategies are more complicated because they do not aim at protecting one's own innovations anymore, but they are directed against the innovations of others, of your competitors. And there we immediately see that there is a little problem, because to impede innovation is not the goal of patent protection, it's not the goal of competition law. So in offensive strategies, we need a closer look. We have to examine where the limits of offensive strategies are drawn in competition law. So in the following remarks, I will first focus on defensive strategies, and then I will go over to offensive strategies. There is an intensive use of defensive patent strategies. I just mentioned two examples. We have a strategy which is called smokescreen patenting. There, a number of patent applications is filed in order to hide the important subject matter. It's a way to confuse your competitors. So you have a patent for your core invention, but you do not want to show your competitors that this is the very heart of your new product. And so you apply for patents for a lot of other surrounding inventions, and you create this smokescreen. I mean, this is legitimate. Why not? This strategy serves the ultimate goal of patent protection to defend your core invention. A very similar strategy consists in creating patent clusters or patent thickets. There, a lot of patents are applied for the same medicine, and it is done because you want to prevent your competitors from getting patents which are very close to your patents. So it's better you get these very adjacent patents than your competitor get them. This is still a defensive strategy which aims at protecting your core innovation. So defensive patent strategies are completely legitimate, no problem with them in competition law. There is one exception which regards fraud on the patent office. Defensive patent strategies which are made on the basis of lying and cheating to the patent office are not legitimate any longer. So there are limits to that strategy. And these limits can be provided for in patent law, or they may be provided for in competition law. Let us have a short look at US patent law. US patent law rather fights against lying and cheating in patent law itself. There is the principle of candor and good faith with respect to the United States Patent and Trademark Office. It means you have to be you have to act in good faith whenever you apply for a patent with the US PTO. You have not the right to lie or to cheat or to omit important information. And if you do fraud or inequitable conduct towards the US Patent Office, then of course you won't get the patent. But US patent law even goes one step further by saying that in this case, all your patent claims are unenforceable, not only those which are affected by the cheating and the lying and the lack of candor. So this goes very far, and the Federal Circuit, which is the Court of Appeals of the Federal Circuit, has said that this consequence, the remedy for inequitable conduct, can be called the atomic bomb of patent law. So in US law, you should definitely not cheat before the patent office because it has severe consequences for a whole bunch of your claims and your patents. This remedy stems from the common law principle of equity. We have these two pillars in common law, which is at law and inequity. And this is an equity remedy. We do not know that in continental European law. So there is no comparable legal consequence to that. For example, when it comes to fraud on the patent offices in the EU, the member states do not have such far-reaching consequences in patent law. Of course, also on the European continent, you must not cheat the patent office, but the only consequence you face if you cheat, if you give wrong information to the patent office, is that you won't get the patent, but there are not so far-reaching consequences as in US patent law. On the other hand, in Europe, we react by competition law to fraud on the patent office. So misleading representations to the patent office may constitute a violation of Article 102 of the Treaty on the Functioning of the European Union, which is the prohibition of the abuse of a dominant position. Fraud is not competition on the merits. Whenever a dominant firm does something which does not belong to the category of competition on the merits, it's abusive. And in order to show an abuse, it is not necessary that someone who has lied to the patent office enforces the patents, but already the fraudulent filing in itself may constitute a violation of competition law. The leading case is AstraZeneca, decided by the European Court of Justice in 2012. There, the European Court of Justice has confirmed the European Commission and the General Court, which had said both that lying to the patent office may constitute the abuse of a dominant position. In the case at hand, the company AstraZeneca had given wrong information on the first marketing of a certain drug in the member states of the European Union to get complementary sufficient certificate, so to have this extension of the patent protection. There was a huge discussion on that case afterwards, because the critics of this decision said that this goes very far. No? Will the pharmaceutical companies be punished now by huge fines every time they give an incorrect information to the patent office? And there the answer is no. The European Court of Justice said no. The establishment of an abuse has to be made on the basis of all circumstances of the specific case. It is not sufficient that the company has erred, has committed an error, has given some information which is not 100% correct. This is not sufficient for finding the abuse of a dominant position. You need more. You need a strategy which aims at getting a protection for something which has not been deserved. So it is not about ensuring moral conduct. It's not like in the Decalogue that you must not lie. It is in competition law about not distorting the competitive process. And if you give misleading representations to the patent office in order to get an exclusive right, and you do it because you want to eliminate competition, because this fraudulent patent will prevent your competitors from becoming active in this field of business, then it's abusive patent strategy, and then you will be punished by a fine imposed by the European Commission. So this is the category of fraud on the patent office. You must not cheat the patent office. I come to the other category, which is offensive patent strategies. Here, patents are filed to impede competitors' innovations. The goal is not any longer to protect your own innovation, but it's now about attacking your competitors and to prevent them from developing something new by placing patents in their field. The particular thing about these offensive patent strategies is that yourself, you never had the intention of making use of your patent. You just get the patent to make the life of your competitors harder. The European Commission made a big inquiry in the years 2000, and at the end there was the report of the Farmer Inquiry published in 2009, where the European Commission has made an analysis of everything which is happening in the European Union with respect to patents. It's a very thorough report from which we can learn a lot of things. And the European Commission said, for example, or summarized here in this quotation, patenting strategies that mainly focus on excluding competitors without pursuing innovative efforts and or the refusal to grant a license on unused patents will remain under scrutiny, in particular in situations where innovation was effectively blocked. So the European Commission starts from the idea that if you apply for patents which just aim at excluding competitors, or if you have a patent and you refuse to grant a license, but you do not use the patent yourself, then we have an initial suspicion that something is not right, and then the European Commission will start specific inquiries, will start procedures against specific companies. The question is how much of all patents granted are not used by the patent owners. And there we had a study which is quite old now, but I don't think that numbers have changed considerably. This study came to the result that 36% of European patents are not used, neither internally nor externally by licensing or by sales assignment of the patent question. In some fields of chemical-based and electronic-based industries, where we have most of the cases, the number of unexploited patents is higher than 75%. That's an impressive number. No? More than 75% of all patents granted in these economic sectors are not exploited. No? Neither by the company, by the patent owner himself, neither by others, because they don't get a license. Yeah. Now, how do we assess this behavior to get patents which then are not used? I mean, there's no contribution to innovation if no use is made. The idea of patents is to give the patent owner the exclusive right in order that he does something with the patent. The two basic questions now are, is the acquisition of blocking positions anti-competitive? If these unexploited patents only serve as blocking positions towards your competitors, is this a problem? The starting point is no, it is inherent to exclusive rights that they block. No? I mean, this is the inner sense of an exclusive right that nobody else can use it. No? So the blocking effect of a patent in itself cannot constitute something wrong. And moreover, it is very difficult to prove that a certain patent is exclusively used in order to block competing products. How do you prove that a certain company has applied for a specific patent with the only intention to make use of this patent to block competitors? Now, there we have a problem of proof that this anti-competitive motivation was there from the very beginning. And the second problem is it anti-competitive to prevent the introduction of innovative products by your competitors, which would compete with existing products of yourself? Isn't it legitimate that you prevent others from bringing to the market products which would compete with your own products? I mean, this seems to be a legitimate interest to secure one's own invention by neighboring or secondary patents. So the assessment of offensive patent strategies is situated in a very complex context, and there are no simple answers. Normally, when it is difficult to give answers to certain questions, we lawyers look at the case law. And here I have to say that the case law is not very advanced. We do not have a specific case telling us under which conditions the applying for a patent is an abusive, offensive patent strategy. At least we have the two cases, Boehringer and Servier. And very recently, we have a new case, which is the Teva case, which I will explain at the end. Let's start with Boehringer. In 2007, the European Commission initiated a procedure for, and I quote, misuse of the patent system in order to exclude potential competition in the area of chronic obstructive pulmonary disease, COPD drugs. So the market is less interesting. It's about medication against smoker's cough, which is called COPD. But the interesting aspect is the European Commission for the first time said that the patent system may be misused and wants to prevent such a misuse of the patent system. What was the background? The background was that the company Boehringer was the market leader for medications against this smoker's cough with its blockbuster drug Spiriva. And according to a competitor, Boehringer had filed for unmerited patents by combining three categories of active substances with a new active substance which had been developed by the competitor. So we are here in a field of a rather complex use of patents. It's the topic of so-called combination patents, where you get a new patent by combining other patents, because the combination will have new results. And the special aspect here was that Boehringer combined three active substances which it had invented itself with a new active substance which had been developed and patented by a competitor. And the competitor was afraid that this combination patent would be an obstacle to his own market entry of its competing medicine, which was a mono product based on this substance for which the competitor had gotten the single patent. So the question was, is this abusive patent strategy? And it would have been so nice to have an answer by the European institutions, but unfortunately for us lawyers, the European Commission settled the case. Boehringer agreed to remove the alleged blocking positions, And the European Commission said a settlement between the parties is the most efficient and speedy way to ensure that consumers will be able to benefit from Almirall's product. So the problem was fixed and there was no need to go on with the competition law procedure. The case was closed. We do not have a precedent on offensive patent strategies. The second case I'd like to mention is the Servier case. The Servier case, you would call it normally a pay for delay case. Now, we know very well now this problem of pay for delay patent settlements. These are settlements which are concluded between originators on the one hand and generica companies on the other hand. Very often they have legal problems because the originator company sues a generica company for patent infringement, and the generica company attacks the originator with a nullity procedure before the patent office and tries to attack the validity of the patent. And so they may solve their problem, but there were many cases where the result of such a settlement was a considerable value transfer from the originator to the generica company. A reason why we call it also reverse payment settlements, because the money does not go to the patent owner, but comes from the patent owner and goes to the generica company. We now know, thanks to a very recent judgment of the European Court of Justice in the case Generics UK, that this is a restriction by object. But this is not the aspect of the Servier case I'd like to mention, but hidden in this case is our problem of offensive patent strategies. Why do I say hidden? Because the decision of the European Commission in the Servier case has 800 pages. So this is another problem of this topic of interface of patent law and competition law. The cases are so complicated. 800 pages, not even the specialists are able to read these decisions in their entirety. But the European Commission identified problems of blocking patents, and I quote a finding of the European Commission. It's found out that between 2000 and 2005, Servier applied for and obtained a number of process and crystalline form patents, which Servier internally referred to as blocking patents or paper patents. According to Servier's own assessment, some of them involved zero inventive activity. So Servier was so, let's say, was not very smart, but you could find emails where the company itself said that our patents do not have any value. We filed them, but we knew that they would not fulfill the patent requirements. And so the only goal of our patents was to block the competitors. I read another quotation: the patenting strategy devised and implemented by Servier therefore consisted of filing as many blocking patents as possible. The patents covered all aspects associated with the molecule, its synthesis, production processes, polymorphic forms, etc. So this was really a general strategy of creating area of patent protection, which was supposed to make the life of competitors harder. And one other aspect on the quality of Servier's patents, there was the revocation of one of these patents by the Court of Appeal of England and Wales. The most important blocking patent was the so-called 947 patent. And the English court said this patent is invalid, and very plainly so. It is the sort of patent which can give the patent system a bad name. So the English court thankfully affirmed that here really a misuse of the patent system is taking place. Such strategies can give the whole patent system a bad name. and this is highly illegitimate to do that. The problem is neither the European Commission's decision nor the General Court based its judgment of this blocking patent strategy, but it was a pay for delay case. So it's not a leading case on blocking patents either. I come to the end of my presentation by mentioning a very recent case which just has been opened by the European Commission last week. It's the TEVA case regarding multiple sclerosis medicine, and the European Commission sees indications of strategically filing and withdrawing divisional patents, repeatedly delaying entry of its generic competitor, who was obliged to file a new legal challenge each time. So we have a patent strategy here based on divisional patents, and the Commission calls its own new procedure as following. This is the Commission's first formal investigation into potential abuses relating to the misuse of patent procedures in the pharmaceutical industry. So everybody hopes now that this will be the leading case on the topic of patent strategies and competition law. Let us see if this hope will be fulfilled. Everybody in the community hopes that there will be no settlement, but a clear decision of the European Commission. My outlook consists simply in quoting EU Vice President Vestager, who is at the same time the Competition Commissioner. She said, it is very important to have intellectual property rights that make sure innovators can be rewarded for their work, but those rewards can't include the right to stop others from developing alternatives. So this is the very heart of my topic. It is patent strategies are legitimate, but their legitimacy ends where they simply consist in preventing innovations from others. Another aspect was mentioned by William Nordhaus. The best way to prevent abuse is to ensure that trivial inventions do not receive patents. So the patent requirements should be fulfilled. The patent offices should be very suspicious whenever it comes to strategies like the strategy of Servier of applying for paper patents. The goal of competition law is not the protection of short-term competition by imitation, but sustainable competition by innovation. And there, as I mentioned in the beginning, patent law and competition law share the same goal. It will be important to reconcile them also when it comes to specific cases. Thank you so much for your attention.
Dear Professor Heinemann, thank you very much for your really insightful presentation. I just wanted to mention few of the things, the most important things mentioned by you. I really liked the way you start the presentation with mentioning the complementarity between the competition law and patenting or IPR protection, and saying that in fact the one promotes the other, but also the strategies companies may apply towards patenting and fighting against competitors. You mentioned about defensive and offensive patenting strategies, and you said that defensive patent strategies are normally compatible with the competition law, whereas offensive strategies needs a closer look. I really do appreciate your case studies on saying that competition patenting should contribute to innovation, promotion, but not to its blocking, and should not contribute to patent unexploitation. So case studies for abusive patent strategies in case of Boehringer, I'm not sure if I do spell this, but also Severe, an example of patent strategy to block competitors, and the new case, TEVA, misuse of patent procedures. thank you very much. I do agree with you that this research field is so wide and so complex. And it's not for a wider public, it's for the specialists that do focus on this field. And thank you once again for your contribution. Because some of the speakers have to leave earlier than we close the session, we will proceed with the Q&A session for you, Professor Heinemann, as I know that you have to leave. We do have a question in the chat from Mr. Professor Penin. I was just wondering if Professor Penin, do you want to address your question by yourself, or if you want to, me to read it?
No, I can ask it myself.
Okay.
Good morning, everybody. Yeah, I was wondering because as you mentioned at the beginning of your talk, more and more often we have a strategic use of patents. I mean, patents are not always used to protect, to secure a manufacturing product. It is used very often in a reputation strategy, sometimes to attract a venture capital, sometimes just to a license. So it's clearly a strategic use of patents. And so to my view, it becomes more and more difficult to claim when a patent is used, when it is practiced, and when it is not. Because obviously all these firms, including what we call patent trolls or patent assertion entities, they, in a way, they are using their patents. They are not using it in the right way, but they are using it. So I was wondering, from a legal point of view, isn't it more and more difficult to make this claim?
Absolutely, I completely agree with you. No? It's such a difficult topic. No? It's so hard for a competition authority to find an abuse. And I think it would be wise to say that you should normally start from the idea that the use of a patent is completely legitimate. So there should be no negative suspicion, etc., not even against these patent trolls, etc. They all may have very legitimate backgrounds and strategies. So the starting point is always to say, this is legitimate. No, this is either a defensive strategy, or even if it's an offensive strategy, it's not illegal from the outset. So it is very important then to have a look on the technological sector and to see in an objective manner if there was any contribution of that patent to the process of innovation, be it on the side of the owner of the patent, be it on the side of innovations of competitors. So you have to look at all innovators in a market and beyond. And then a competition authority has to analyze if there was any use for innovation in that strategy. And if there is no contribution of that strategy for the process of innovation, but if you can find, perhaps with such wonderful emails which have been found in the Servier case, that it was really completely a destructive patent strategy, then you may conclude that it is an abuse. But I completely agree with you. It is difficult, and probably it's getting more and more difficult because patent strategies get so sophisticated. And let us see the new, let us await the new TEVA procedure of the European Commission. Perhaps we will learn more about the legitimacy of divisional patent applications, which is one of the strategies which are used heavily. Yeah, thank you so much for your question.
Thank you, Professor Heinemann, for your answer, and Professor Penin for your question. I was wondering if there are any other questions for Professor Heinemann or for Professor G. Robles. If there are no more questions, I cannot see any other question in the chat. Thank you, Professor Heinemann, for sharing your presentation with us. Thank you for contributing to the success of this event. Thank you once again.
You are welcome. It was a pleasure.
In fact, the question we had is kind of introduction to the new speaker on our agenda, namely Professor Julien Penin, which is a professor at the Faculty of Economics and Management, head of the Bureau d'Économie Théorique et Appliquée, University of Strasbourg, with the presentation of obstacles or accelerator of innovation, intellectual property at crosswords. Professor Penin, the floor is yours.
Okay, good morning everybody. So I start sharing my slides. So normally it should be fine for all of you. So thanks a lot for the invitation. Thanks a lot for the organizer. Also, the timing is quite good because I guess my presentation will be quite complementary with the previous one. The previous one was more on the legal aspect. I will discuss a little bit more on the economic aspect. I'm a professor in economics. Basically, the topic of my talk is starting from a kind of a paradox. We all know that intellectual property rights, patents are becoming more and more important in the knowledge economy and so on and so forth. And so obviously it's very important to pay attention and to stress intellectual property policies, but on the other hand, we know that at least when it comes to patents, and the topic of my talk will be limited to patents, but when it comes to patents, we know that there is something going wrong with the system. We know that firms are increasingly using the patent in a strategic way, and this induces some problems. And so I will not have time to emphasize a lot and to define, what is patent trolls, anti-commons, multiplication of patent litigation. But we know today that the patent system basically is not working very well. And so it's very important to understand why, if we want to be able to tackle and to eventually to solve the problem, it's clearly important to understand what is the root of this problem. And one of my hypotheses and one of the thing I want to discuss with you is that maybe a very important dimension of the patent system deals with what I call the quality of patent information. So it's a little bit different from the quality of a patent. The quality of a patent, it is related to whether or not the patent should have been delivered. Sometimes, and we have just talked about, sometimes we have trivial patents, patents that are not really novel, not really inventive. Patent offices, they make mistakes, and sometimes these trivial patents, they are validated, they are granted. This is not the topic of my talk. My talk is really related to the quality of patent information, that is all the information that make it possible for users of the patent system, so patent applicants, but also other firms, public administrations, venture capitalists, financiers, all the users of the patent system, in which way it is easy and not too expensive for them to find the information that they need. And this is what I mean, the quality of patent information. Just one example. You are a manufacturing firm. You want to introduce a new product on the market. Basically, the first thing you need to do what we call a freedom to operate analysis. That means you need to identify the patents that potentially you might infringe. And that is important because that will enable you to negotiate ex ante licenses. You can negotiate a license before you go to the market. And this is going to be less expensive, less problematic than what we call ex post licensing. And so it's very important to do freedom to operate analysis, to identify the patents that you might infringe. And to do so, you need to be able to look at the patent databases, to scan patent databases in order to find the relevant information. And one of the paradox today is that this is very costly. This is very costly because in some countries, in some sectors, we have a lot of patents, sometimes 10,000, 100,000, sometimes millions of patents. These patents are not very clear. Sometimes they are drafted in order to be difficult to understand. So the border, the frontier of the patents are not well delimited. And sometimes you don't even know who is the real stakeholder, who is the real owner. So you know, you have the information about the applicant, but maybe this patent has been sold or licensed to a patent troll and you don't have the information. So this is all what I'm talking about. This is what I call, the quality of patent information. And clearly today, one of the main problems is that the quality of patent information is very bad. It's very low. And one of my guesses, and one of the things I try to analyze, to explore in my research, is to show that this is one of the most important problems with regard to the bad performance of the patent system today in some sectors and in some countries. And so this is what I want to discuss with you this morning. So let me start by one, I think, very important qualification. Clearly, when it comes to the performance of the patent system, the efficiency or inefficiency of the patent system, it's difficult to make, a global kind of universal talk or diagnosis because we know that we have huge country differences. The situation is clearly not the same in the US, in Europe, or now in China, or the problematic is also quite different from the developing countries. So we have huge country differences. We have very important sectoral and industry specificities. We know that the situation and the consequences, the economic consequences of patents in the pharmaceutical sector, they are quite different from the economic consequences in ICTs or electronics. So we have huge industry differences. And also one of the points that also make it even more difficult to discuss is that it's not only a problem of the patent law, it's a problem that goes far beyond patent law because it's also a problem that deals with the national property of the legal system. For instance, when you talk about litigations, okay, it's clearly beyond the patent law. You know that different countries, they have different litigation systems. And so that is also part of the solution or the problem. So it's a problem that is much broader, to my view, than just patent law. Okay, so let me start by the beginning. To be sure we are talking about the same thing. As I said, I'm a professor of economics, and you know that economics, they have a very specific view about intellectual property. Economists, they use to justify the existence of patents based on consequentialist or utilitarian arguments. So usually economists, they are not really, they don't really believe, in a deontological or moral rationale that are sometimes very important, but clearly this is something, economists, they do not really feel easy with this type of argument. So we believe, in consequentialism, in utilitarian. And so the basic economic arguments, obviously, to justify the existence of the patent system, it is what we call the second best view, and that has been developed. And we just talked about Nordhaus in the previous presentation, but it has been developed by also, Kenneth Arrow or obviously Joseph Schumpeter. And it's a view that says that we need patents because patents are very important in order to generate dynamic efficiency. So if you want, patent law can be viewed as a way to balance static inefficiency. So static inefficiency, you know, it's about the dead-weight loss of monopoly. We know that monopoly, they are going to increase prices. And so monopoly on the short run, they are bad. This is what we call static inefficiency. But on the other way, in an ideal world, patents, they should create more innovation. They should contribute to disseminate, to diffuse knowledge. They should fight against any form of secrecy. And also they should facilitate open innovation. And that's a point on which I will come back on the next slide. And so basically we have a view that says patents might be costly on the short run. We need to accept monopoly today, but if you want, that's the price to pay if you want more innovation, more welfare in the long run. And so it's a story about dynamic efficiency. Okay. One very important argument that has emerged in the last, I would say, in the last 2 decades, following, you know, this huge literature that we have seen in management science, huge literature about open innovation. So we have seen clearly the emergence of a link, a connection between patents and open innovation. Basically, I don't want to enter in the theory of open innovation. I guess many of you, you know the work of Henry Chesbrough, but open innovation, it's just a theory that says that if you want to be innovative, successful innovation needs interaction. You need to interact, you need to be open, and you need to exchange information, knowledge with suppliers, with customers, with sometimes competitors. But you need to be open. You need to interact. And what is interesting is that whatever the type of interaction, in any case, patents might help to develop this external interaction. And because the idea, you know, the intuition is very simple. Patents might facilitate the practice of open innovation, basically because open innovation is risky. It's always risky to interact with your external environment, because when you interact with outsiders, you take the risk to lose some information, to lose some trade secrets, and so it's risky. And basically, patents might be a way. And when we say patents, it's intellectual property rights in general. It's a contract, any type of contractualization. But we need contract, we need patent to secure the interactions and to avoid opportunistic behaviors, and to make sure that you will collaborate, you will interact safely with the external environment. And so basically that's a new way to envisage the economic role of patents. In this way, if you want, a patent might be useful not only to exclude competitors, not only as an exclusive right, but patents might also be useful to include collaborators, to facilitate interactions, collaborations. So from a view of patent as an instrument of exclusion, we switch to a view of patent as an instrument to include and to collaborate. So that's an interesting move. But again, the argument can be summarized in a very intuitive way by the nice formula that you know, good fences make good neighbors. You know that economists, they like very much this expression. We believe, as economists, we believe in property rights. And so we believe in intellectual property rights because property rights is supposed, you know, to limit the property of all the economic actors, and so to facilitate interactions. And so good fences make good neighbors, and so good patents should make good open innovation, should facilitate interactions and collaborations. And so this is again a very nice way to justify the economic role of the patent system. The problem is that this is very nice in theory. In practice, it's very often slightly different. And so we have seen in the last years a kind of contestation that has emerged and that is now growing. And again, what is interesting is that scholars who today are contesting the patent system, it's not people who do not believe in free market. It's not people who do not believe in capitalism. It's not, open source guy. No. If you just look at the authors of the books that I have on these slides, Adam Jaffe, Josh Lerner, and others, they are bright, very smart US scholars working in the best US universities, Princeton, Stanford, Harvard, and others. And they clearly, they are professors of economics and law. They clearly believe in free markets. They believe in property rights. They believe in capitalism. And they tell you there is something wrong with the patent system today. Clearly, there is something wrong with the patent system today. We are talking about, hold up, trolling, anti-comments, and all these things, but clearly there is a problem with the patent system today. And so we need to understand why. We need to understand why. And as I told you in introduction, maybe one explanation deals with the quality of patent information. So basically my guess, my conviction, and what I try to emphasize in my research is that there is clearly one unique route to all this discontent, all these dissatisfied people. Basically, the same route is the bad quality of patent information. Okay, so this is, and if you want to continue on this formula, good fancies make good neighbor. Good fancies make good neighbor. This is true, obviously, if we have good fancies. And good fancies suppose that you have good information. And that is very important to have good information about the fence. It's very important to know what is protected, what is not protected. And this is the aim of a good fence. And the aim of a fence is to make sure that there is no uncertainty about what is your own property and what is your neighbor's property. If you don't have good information about the fence, obviously you cannot tell that bad fences make good neighbors. And so one of my conviction today is that maybe patents, they don't offer good fences. It's more likely that in many sectors, they offer fences they are not this good. It's very difficult to understand what is really protected, what is not. And so that is the source of many inefficiency of the patent system. Okay. So let me now move to clearly why do we have bad fences? Why? And again, keep in mind that this is not the case in all the industries, and this is not the case in all the sectors. Okay, it's very important to keep in mind that the situation is much worse today in the US than in Europe. The direction is not very good in China. It seems that the Chinese system is more or less copying the US system for many reasons. So, but maybe it's not the good direction to take. And also keep in mind that the situation, for instance, is very different in ICTs, in electronics, than, for instance, in chemistry, life science, or pharmaceuticals. So why do we have a low quality of patent information? First point, obvious one, we have a lot of patents in force today in the economy. And obviously, the more patent we have, the more difficult it is for firms to understand and to handle patent information. If in a domain you have only 10 patents, it's very easy for the actors, I mean, to understand the situation. If in a single situation you have thousands, 10,000 patents, it's much more difficult. So the quantity of patents obviously leads to a scaling problem. And just to give you some figures, in the US today, in some sectors, you have some inventions that are protected by 10,000, 100,000 patents. And so when you think about freedom to operate analysis, obviously it's a nightmare for the actors of this domain. So we have a big number of patents. On the top of that, we do not have a reliable patent index to classify these patents. So we do have patents classification, but what is important to understand is that this patent classification, the IPC, for instance, it does not work like a land public registry. You know what we call in French, we have a cadastre. And the land, if I look at the land, you know that land property in most developed country, land property is registered in a public registry, and the information is clearly defined, it's made public, and if you want to buy or to sell a piece of land, normally you have no informational problem. This is obviously not the case with patents. Today's patents classifications, they don't work like a land public registry. Okay, so we don't have the equivalent of a cadastre. And so that means, for instance, if you have an invention that fits with, let's say, one patent class, it's not sufficient to look at the invention that are only in this patent class, because you can infringe a patent that would be in another class. And so if you want to identify your neighbors, if you want to identify your technology neighbors, it's much more difficult. So I'm not naive, and I discussed with a lot of lawyers and engineers, and I totally know that it's going to be very difficult to converge towards the equivalent of a land public registry. We are talking about intellectual property, not tangible property. We are talking about technology that is something that is moving, that is evolving. We have new technologies that are invented every day. So it's clearly difficult to have a mapping. It's difficult to have a cadastre, but still maybe we should try. Maybe we should try to go towards this direction. Third problem, in addition to the land public registry thing, we know that very often, if you identify a patent that is relevant for your business, it's very difficult to understand the perimeter of protection of this patent. Even if you take some experts, even if you take some neutral experts, you give them the same patent, they might disagree about the perimeter of protection. And one expert might say, obviously there is an infringement. The other expert will conclude that there is no infringement. This is again because we are not talking about a physical, tangible property. It's, you know, it's immaterial, and it's very difficult to understand sometimes what is protected, what is not. And related to this point, we know some studies has shown that this problem is much more relevant in domains where knowledge is less codified. For instance, if you look at chemistry or pharmaceuticals, very often you talk about molecules. Molecules, you have a formula, and so it's much simpler to understand when there is an infringement or not. It's much simpler to understand if you have what is the perimeter of protection when you have codified knowledge, when you have a formula. In other domains, let's say, for instance, software, very often you are using words, English or other languages. And so you know that words are obviously less precise than mathematical formulas. And so that adds some uncertainty to the perimeter of protection. But still, it must be clear that in many cases, it's difficult for the actors of the domain to understand what is protected and what is not protected by the patent. And last problem, very often, patent stakeholders are not easy to identify. Very often, what you can find in the databases of patent offices, the public databases, you will find the name of the applicant. But very often, what is missing, it's the name of the stakeholder. For instance, if the patent is passed to another company because the applicant went bankrupt, and so the patent was bought by another company. If the patent is exclusively licensed to another firm, it's not mandatory to immediately to signal it. It's not mandatory to publish it in a public database. And so sometimes it's very difficult for, again, for the actors of the patent system who are doing patent mapping, who are trying to identify who is owning what. It's very difficult to identify the real owners, the real stakeholders of a given patent. And that might also be a problem, especially with regard to the patent trolling issue. So this is why basically I think that we have a problem sometimes with the quality of patent information, and again that is the source. And so I will not have time to demonstrate it, so I will not have time to discuss it, but I can send a lot of papers that are about this connection, this link. We can show that this low quality of patent information, it's one of the source of most of the problems that we have today with the patent system. When we talk about transaction costs that would be prohibitive in markets for technology, it's a lot about the bad quality of patent information. When we talk about patent tickets, anti-commons, when we talk about the multiplication of patent litigations, it's not only, but part of the problem is related to the low quality of patent information. When we talk about hold-up strategies, patent trolls, it's the same. Most of the problem is linked to the low quality, the bad quality of patent information. For instance, just let me give you the flavor of the intuition for patent trolls. Patent trolls, what is the strategy of what we call a patent trolls? So we have many different characteristics. It's a multi-dimensional problem. A patent trolling, it's not only one dimension, but if you look at the economic dimension of the problem, the main characteristic of a patent troll is that they want to provoke hold-up situations. They want to put manufacturing firm in a hold-up situation. What does that mean? That means that patent trolls, they sue manufacturing firms, but they do not sue early in the manufacturing process. They wait and they want to block, they want to make it very difficult for the manufacturing firm to go back. And so they want to place the manufacturing firm in a hold-up situation. So imagine you are a manufacturing company, you invest in the development of a new product, you put the product on the market, you start selling the product, then it's very difficult for you to come back. It's very difficult for you to stop. You are engaged in an irreversible way on a given trajectory. And it is precisely at this moment that patent trolls will attack, because they know that you will be in a very bad negotiation position. You will be placed in a hold-up position, and you have no other issue than to accept a take it or leave it offer. This is the economic strategy of patent trolls. And so basically patent trolls, they play on the low quality of patent information. They benefit from the fact that it's so difficult for manufacturing firms to do freedom to operate analysis. Since it is so difficult to do freedom to operate analysis, it's very easy for patent troll to provoke hold-up strategy. In a world where perfect information, in a world where patent information is good, it would be much more difficult for patent trolls to operate, because it would be much more difficult to hide patent. And so manufacturing firms, they could identify the patent early in the process, and they could negotiate ex-ante license, or they could do something else. But in a world where patent information is so bad, it's very difficult for manufacturing firms to identify the relevant patent, and so they will be trolled. They will be placed in a hold-up position. So clearly there is a straightforward link between the low quality of patent information and patent troll. So I have 2 minutes left, so let me move to the conclusion. And obviously, you know that economists, we have a lot of questions, and sometimes we even have very good questions. And the problem is that we have very few, very little answers. And so that's exactly the case for this problem. And so what can we do? What can we do with that? Obviously, I have no miracle solution. It would be too easy. What is clear is that none of these problems are intrinsic, inherent to the patent system. And clearly some realistic patent reforms could maybe not solve all the problems, but could help to go to the right direction. And so it would be clearly possible to operate some changes, maybe to improve the quality of patent information. So I don't have time to detail all the possible solutions, just one or two questions. For instance, I think it's very important to fight against any form of secrecy. And this is, again, secrecy. You know that economists, they like perfect information. They like when information is good. They don't like secrecy. Secrecy is not good for business, basically. And so it's one question, for instance, is what is today the justification of the 18 months of lag between the patent application and the publication of the patent application? Why do we have to wait 18 months? And during these 18 months, you have a patent application that is invisible, that is not very good for the business. Why, for instance, we do not create a public registry in which it would be mandatory for firms to declare the licensing deals or the exchange, the market deal of patents. So it would be possible to identify who is clearly using the patent. These are just some examples. So some other things can be done, but I'm running out of time. But clearly, it would be possible to do something to improve the situation. We cannot be satisfied today with the current situation. So, conclusion, that was clearly a warning message. As most of the economists, I'm not against intellectual property. On the contrary, we do believe that intellectual property are very, very important in the knowledge economy. They can be an extraordinary facilitator of open innovation, but still we need to improve. We need to improve the situation. We cannot be satisfied with the situation that we have today in some countries and in some sectors. So I'm already late, so I stop there. Thanks a lot for your attention, and eventually we can discuss if you have some questions.
Thank you, Professor Penin, for your very interesting presentation that was focused on the quality of patent information, which is one of the main challenges in some industries. You mentioned about those institutional and country differences in patenting, which are in some sectors determined by some cross-sector specificities. You mentioned about those rationales, which are mostly traditional as consequentialist, utilitarian, and deontological, but also you mentioned about the new approaches towards patenting. Yeah, and especially those promoted by Schumpeter, Arrow, or Nordhaus, that focus on the efficiency of innovation, and that innovative firms must interact with the others, having that very fancy statement, yeah, good fences make good neighbors, which is based on one central assumption: patents provide good fences. You mentioned also about the bad quality of patent information that is determined by the high number of patent applications, no reliable patent index so far, that patents are difficult to read and to understand, and sometimes patent stakeholders are not very clearly identifiable. I really liked the solution that you came up with, those challenges you mentioned throughout your presentation, and namely fight against any form of secrecy, improve the way patents are drafted, and work on reliable patent index. And of course, the idea that we need a more evidence-based policy, patent policy, that's the final word. Thank you so much once again for this very important messages, which do represent important trends in the economic theory. Yes, we do have one question in the chat from Professor Heinemann, but I will leave the floor to, or the chance to Professor to address directly the question to you. Is that okay?
Thank you. Great presentation. Thank you so much. And you propose better patent information. At the same time, you mentioned all these patents outside. So my question would be, would you propose just to improve patent information, or would you also opt for reducing the number of patents? And perhaps an additional question, you mentioned the differences between Europe on the one hand and US and China on the other hand, and you said the US have a bigger problem. Does it regard also, or perhaps would you propose different reforms for these different jurisdictions because they have different problems?
Yes, thank you. Thank you so much for the two questions. As to the first one, yeah, clearly these are two problems that are complementary and they go all together. I would say in an ideal world, you know that economists, we like to consider an ideal world. In a world where information is perfect, the number of patents is not a problem. Because clearly it's easy to deal with we have the perfect information to deal with all these patents. We know that it's an utopia. Patent information will never be perfect. It's not possible. It's immaterial. It's intangible. We are using words, so it will never be perfect. So obviously, the number of patents can be a real problem. This is much more difficult to do because where do you put the bar, you know, to accept or not to accept a patent? That's, you know, much better than I do. And that's a question that is very difficult. There is a lot of interpretation of the different patent offices, interpretation of the lawyers, the judges. So it's the question of the quantity of patents. I would say it's a much more difficult question. The only point on which I think we can all agree is that we need a minimum of bad patents, and that's just obvious. And the most important requirement for patent offices is to make sure. I like very much the expression of my colleague Dietmar Haroff. He's a famous German economist. He used to say that patent offices should be considered as the guardian of the temple. Their mission is not to accept patents, it's to refuse patents. They should consider that their mission is to refuse patents. They are the guardian of the temple. And so we must make sure that we have a minimum of bad patents in force in the economy. I think that's important to remind. As to the second question, yeah, I think it's very important to keep in mind that it's a problem that is going beyond the simple patent issue. It also deals with, you know, the litigation, the law system of countries. And if you look at the situation, for instance, in the USA, they made some changes with the patent law, but still they have a legal system which is very costly, very expensive, and which makes it very difficult to operate for small firms or firms coming from abroad. And so obviously, I think the situation is different across countries, and we need to adapt the solution. For the moment, Europe is relatively protected, but that can change very rapidly. We need to pay attention to the situation, and the examples that you gave, they go in this sense.
Thank you, Professor Penin. We have one hand raised by Natalia Mogol.
Yeah, thank you, Radhika, and thank you for your great presentation and very important issues raised about patent quality and the quality of the patent information. But as the representative of the IP office, I cannot agree with this statement that the office shall be not an office of registering patents, but of rejecting patents. And I do believe we shall keep the balance between the interest of the inventors and of the market interest. And I do believe that the fact that more and more countries introduce special fees for the maintenance of the patent somehow keep this balance, because you know that inventor or the holder of the patent, even if the patent is registered, has to pay for each year of maintenance of the patent, and the fee is increase, and at the end sometimes it is a very important sum of money. So somehow this work like balancing tool. But congrats for your presentation and for issues raised by you. Yeah, thank you.
Thank you very much, Natalia,
thank you very
for your
much.
comment.
No, you know, it's I totally agree on. It's important that you make this qualification, and you know, it's also my role to be a little bit provocative. That's what I try to do. Obviously, it's important to find a balance, but maybe more important, it's also important to make sure that, you know, the incentives go in the right direction. And just to give you 2 or 3 examples, you mentioned the patent fees. And clearly the patent fees, they play a very important role just, you know, to clean the field and to make sure that technologies that are obsolete, they do not remain patented. So it's a good example of how we can create adequate, good incentives. Sometimes incentives are not this good. I discovered a couple of years ago, that 2-3 decades ago, so it's not the case anymore today, but 2-3 decades ago, US patent examiners at the USPTO, they were rewarded and they had a bonus calculated on the basis of the number of patents that were granted. This is a very nice example of a very bad incentives. Everybody can understand that if you give a bonus that is calculated on the basis of granted patents, the message that you deliver is that you must grant more patents. So it's not the case anymore, but as far as I know, at the USPTO and at other patent offices, examiners, they have a reward that is calculated on the productivity, that is on the number of patents that are examined. That is much better, but still, eventually there is a problem with that because to my knowledge, it takes more time, it takes less time to accept a patent than to reject a patent. When you reject a patent, you have to justify, eventually you will have a reaction. So basically, you know, maybe the incentives is still not as good as it could be. And so that is on that types of things that we should maybe improve. But clearly, I totally agree with your points that we need to reach a balance, and it's also obviously important to accept a patent application when it is legitimate.
Thank you for the discussion. This is the fascinating thing of the conferences. So the discussions after the presentations, but we have to keep track to the program that we do have. There was mention today about the new digital era that provides a lot of opportunities, but also raises a lot of questions and challenges when it comes to protection of intellectual property rights. So I want to invite the next speaker, which is Matilde Pivis, which is a PhD senior lecturer in law, Director and Deputy Director of Education of Exeter Law School, University of Exeter, with her presentation, the impact of artificial intelligence on the use of the protection of performances. Matilde?
Yes, I'm going to share my
floor is yours.
screen. Thank you so much. So let's see if I can make that happen. Okay, so you should be able to see my screen, and I'm hoping that I won't have to turn off my camera, but I've had some internet connection issues, so I think the platform will let me know if that's the case, and in which case I might turn off my camera. So I'm going to switch gear, but just before, thank you so much for the invitation and for organizing this very lively event online. It's great to be here. So I'm going to come at this sort of discussion from the point of view of the creative industries, and more specifically, I'm going to talk about artificial intelligence as one of the newest challenge from the copyright and performance rights end of intellectual property, and focusing specifically on performance rights. So the topic could be very quickly referenced as artificial or AI, artificial intelligence and performance rights. Now, you will have heard quite a bit about artificial intelligence and copyright, and that's largely because, or no doubt, that's because we've had a lot of sort of key headlines on the topic. We've had the first AI-made painting sold at the auction by the auction house Christie's a couple of years ago. We've had the first music recording deals happening and being signed by Warner Music Industry, for example. That also generated a lot of attention around, can you copyright AI-made work? Who is the author? Who's the owner, etc., etc. But AI doesn't just make work in the meaning of copyright. It also can dance and produce performances in the meaning potentially of performers' rights. And that's the topic I want to focus on largely because it hasn't been so discussed or debated or explored at the moment. And since we're in a conversation in a panel about the new directions and recent challenge of intellectual property, it seemed to be suited to do that. So you may be wondering, what type of AI-made performances are we talking about here? And I'm going to show you an example, for example, to give you kind of situate some of the debates. I'm just going to fast forward on that video. So what you're looking at right now is an AI-made choreography, so copyright, performed by an AI with absolutely no human involved. Now, you're probably looking at this and thinking to yourself, I'm not watching the biggest threat to the intellectual property framework or performers' rights or any other intellectual property right, really. And you might be thinking that, you know, it'll be a couple of years before you want to hit the statute books and make any amendments or review. And you're probably right. Because this is AI-made dance by an AI performer or robotic and AI performer, but the routes to market aren't really obvious like that. Here is another example. So that's Lumin AI by engineers and performers in the US who have designed this dome in which you can dance, and there'll be a sort of a replica of yourself. And next to you, you'll have an AI dancer, so you'll never have to dance alone ever again in your life. Now, again, you're looking at this and you're not thinking business models all over and real need for intellectual property assets to be protected through intellectual property rights. The commercial, cultural, education strategies or applications that would come out of the two examples I've just given you do not scream intellectual property policy today. However, you may be more familiar with this. And I intend for this one not to be shared, but it might kind of get started. So this is also, so that's Salvador Dali, right? Except that it's not him. You may be familiar with that particular performance because it's a deep fake. It's a deep fake of Salvador Dali that's made with available recordings that we have of him. And of course, deep fakes have been much more prominent and dominant in the debate recently, and in the public and experts debates from all sorts of viewpoints, not just intellectual property. So my little deepfakes are going to start talking, and hopefully they're not going to be too loud to cover over my sound. But deepfakes are another form of AI-made performance that we should explore and consider from the viewpoint of performers' rights, not just copyright. And deepfakes are synthetic performances, that is, digital performances entirely made by or with AI systems. And deepfakes are made from existing protected or potentially protected recordings of performances, so sound recordings or films, that look like they've been manipulated in order to produce an entirely new fake performance by the same person represented in the deepfake. Now, that's not a presentation about deepfake, but I do need to say a couple of sort of features and key salient aspects on deepfake to understand the need to look at and review the IP framework in light of AI-made performances, because they bring in that sort of really compelling case study or sort of need. So the novelty of deepfakes is that the AI technology is designed to work on any sorts of input data. And by that, I mean that it can use still photographs, moving in images like in films, or sound of low or high quality. And it can also work from sort of a very, very small, tiny sample of data across the board. The technology to generate deepfakes or to make performance synthesization using AI is available in open access online. So that has allowed a complete decentralization of this type of AI-made performances to happen. So anyone can have access to it. Anyone can make their deepfake. I mean, that statement is a slight exaggeration today, but soon definitely will be the case. And it can make good to high quality synthesization of existing performances. So, and actually deepfakes are not just about making replica or imitations of existing performers or people. It can also be about complete synthesis. That means creating completely new digital avatars of people that don't really exist at all, actually. So, as I said, deepfakes is not the focus of this presentation. They're just a compelling case study or reason to consider performers' rights in the context of AI-made performances. And I won't dwell on the specifics of regulating deepfakes in the context, especially of malicious or illegitimate uses. But I do want to think about them also in the context of legitimate, lucrative commercial uses, because that feeds into our discussion about intellectual property, innovation, and markets. What I'm interested in, however, is this question: how does IP react to or engage with performances that have been used by AI, that have been manipulated by AI? And when performances are generated using AI and using AI using protected material, such as performances, is the new synthetic performance that's generated through that process, is that an infringement of the performer's rights in the first place? And who is the performer of this synthetic performance of the deep fake? Is it the person that's represented in them, even though they never performed, or the routine or said the words that are attributed to them in the resulting output? Is it the AI? Is it someone else connected to or responsible for the making of that performance altogether? These are the sort of key big questions that are coming up. And what I want to stress at this point is that it's actually answering those questions is not going to be a copy paste of answering the same question in the context of copyright. So when we're looking at AI copyright, we also need to look at AI performers' rights separately, because the issues, although they look the same and the laws are written really, really similarly, they're different. There are key differences in regime that we often forget, because performers' rights is a little bit a Cinderella discipline in sort of the intellectual property framework. But so when we are asking ourselves those questions, we do need to consider copyright on the one hand and performers' rights separately. Not that there can't be any kind of cross-fertilization across the two discussions, but the issues in law are quite different, and to an extent also, therefore, in the way law perceives technology and the use of data. So, for example, when very recently the UK Intellectual Property Office asked experts to submit evidence on the extent to which we need to adapt the intellectual property frameworks in order to meet the challenges of AI, but also make sure that AI innovation continues to happen. And my response to that was, do not forget about performance rights, because you'll find that you will not be able to copy and paste the answers you have on this issue in the context of copyright into performance rights. The recommendations will have to be slightly different. And what I want to do with the time I have with you is to share with you why the answers have to be different, and therefore also the questions that we ask have to be asked separately. The conversation is currently ongoing in the UK, so I'm feeling like I have UK law on the brains, and I'm going to kind of sometimes refer UK law in this conversation, and so that's what's going to happen. But obviously the principles at play in UK law are also coming from international law, and they're relevant whether you're looking at the Rome Convention 1961, the WPP Treaty 96, or the Beijing Treaty. So if I'm talking about UK law, I'm also talking about international law, and actually I'm talking about a lot of jurisdictions, because there's a good deal of harmonization on this point across the world. So performance rights protection is not great, but the good thing about it is it's not great across the board. So in a way, there are sort of certain benefits to that regime. And I know these days it's sort of, the UK is probably not your favorite jurisdiction, and there's something a bit painful and awkward to be talking about UK law in a same panel as one of the highest official, of the European Union, having served and being with us. But my comments kind of transfer across to international law, to many other jurisdictions. So if you want to think about another country, as I'm saying UK law, and replace that in your mind with a different jurisdiction, go for it, because it's very likely to apply all the same. So a quick word on how AI made performances come about, and basically a quick word on the technology itself, because that leads into our conversation in law. We do need to understand how the technology operates, at least on some basic level, in order to see the extent to which it challenges or not our legal framework. So a brief word on AI, and I promise to keep that brief. Terminology first. When I'm talking about AI-made performances, I'm talking about the synthesization of performances using a tool called AI. So AI is just a tool that accelerates a process that is creating synthetic new performances from scratch or using pre-existing material. And you can call that AI synthesization, you can call that performance synthesization, they're all kind of the same. Deepfakes happen to just be one subgenre or one type or one example of that use of technology. And terminology here is useful. Reminding ourselves that we're talking about synthesization of performances is helpful to an extent, because it helps us remind ourselves that this type of use creates completely new data, synthetic data. And it's not a case of copy paste. It's not a case of remixing or some fancy digital collage. And this is, you're probably seeing where I'm going with this. It's not going to be one that's going to straight up work with our traditional right of reproduction, in the sense that, is defined in performance rights. So that's kind of what I want to flag here with this sort of careful wording. So here's a simplified version of what happens when you want to synthesize performance with AI. And by the way, the word synthesization, when you're a French speaker, is a bit of a tongue twister, but I hope you kind of get what I'm saying, or what I'm trying to pronounce. Here's how you would, a basic simple explanation of how you would make an imitative synthetic performance, so a performance that's brand new, but looks like someone and is doing something new with that person's face, voice, or body. And obviously you can sort of imagine a deepfake in your head, if that helps representing what I'm describing here. So a synthetic performance, an imitative synthetic performance, we'd need an AI model as a tool. And that at the moment is using neural networks, which is the latest generation of AI. And actually it's using more than one. In order to generate a deepfake, even half good, half decent, you need a collection, a network of different networks put together. And it's quite difficult. So we are talking about advanced, latest generation of AI technology. And it will be some time before we can produce compelling, very flexible, high quality deepfakes from our phone. We will likely get there and soon, but it's not right now times that I'm talking about. So it's not an easy task in terms of the technology, and it requires a complex arrangement of networks. But to keep it simple, we're just going to imagine the sort of the model, the AI neural network as its own little thing. Now, what needs to happen then is that you need to feed that AI, that model, that neural network, two types of data. So two categories or two groups of data. The first one is that you need to feed it the data from the person that you want to sort of imitate in the resulting output. Say you want to keep their face, so it will be data that will be used in order to extract data points speaking to their likeness, their voice, the way they move, anything that makes them unique in the way they perform, act, and behave. And then you'll need, and that's what we call the target performer, because here we're trying to imitate, create a synthetic performance that imitates them. You don't have to, but that's kind of the example I've chosen. So that's one set of data that we need. And obviously that will be photographs, recordings, and films of that person. And then we need another set of data that is the data often of what we call the driving performer or the puppeteer. And what we'll get from that second set of data is the new routine, the new thing that our synthetic performance will be performing. So it can be a new speech, it can be new words, that will include facial expressions, it can include a new routine, they can perform a new dance or whatever it is, walk a different way, etc. And from that, we will kind of combine the data sets from the first group and get the data that we need from the second group. And then that will give us our deepfake, if we're looking at a deepfake model, or our synthetic performance at the end. What's important to understand is that it's not remixing, it's not a fancy collage that's happening between two groups of data. What AI does when it's grabbing onto this input data is that it really finely analyzes and learns from it and is able to separate things in a way that we humans, our eyes and ears, cannot. So to give you an example of what it does to the target performer, when it grabs onto that data that represents or conveys the target performer, the neural networks are able to separate what the data and the data points that pertains to what makes that person look like this person that we all recognize from the data points that speak to what they do and what they say. And it's capable of separating that. Now, that's not something that we can do as humans with our human brains. And that's something that's also fairly difficult to do with other CGI or visual effects technology. And they do the same with the driving performer. With the driving performer, what the neural networks do is that they analyze it, they separate what the data points that convey the likeness of the puppeteer, the driving performer, and they only retain the data that pertains to the new routine that needs to be transplanted into the synthetic performers. So it's a really smart, fine, clever, inhuman filter, if you want, of data points that separate information that speaks to how you look like, how you sound like, your unique style of performance, your embodiment, from what you do in order to be reassembling it later. But as it does that, it generalizes from the data. That means it creates, predicts, imitates, produce new data that imitates those fine points of data that it extracted. Now, I'm hoping that makes sense or it's somewhat clear, but maybe it's not, in which case we can take questions in the Q&A, or I can, share reading bits and items of people who I think have done a description that's brilliantly clear. But what I want to convey, if anything, here is that this process is new. It's new from the standpoint of intellectual property. It doesn't compare to a classic case of reproduction, not at least of performers in the context of performers' rights. And there's no comparison. We can't draw parallels with remixing. We can't draw parallels with other types of digital use that we've had before. And importantly, this way of using performances doesn't fall within the scope of performers' rights as we have it today. Why? For a very simple reason, actually, that we often forget and that we often overlook is that there's a difference between performers' rights and copyright. And the difference is that performers' rights do not cover the reproduction of performances. Simple, but also a bit puzzling if you haven't thought about or worked on or studied performers' rights in a long time. So let me unpack this. Performers' rights do cover, so part of the rights in performers' rights is the right to consent or authorize the fixation of a performance in a recording of a performance. So you fix a performance in a recording, sound, or film, that's a right, part of performers' rights. Another right of performers' rights, and the only other economic right, is that performers' rights cover the copies and reproductions of that recording. In other words, performance rights attached to the recording. You get to say yes or no, I want to make a recording of my performance, and then you get to say yes or no, I can control how this recording is used. What performance rights doesn't do is give you rights to the substance of your performance or to the performance itself. You can control the making of a recording, you can control what happens with that recording after, but you can't control what the recording contains. You can't control the performance. So other actors can re-perform without infringing your rights, and you can be imitated by other people without infringing on your rights, as long as they don't use clips or bits of the recording as they do this. It has to be a complete re-performance on their part. So sound alike, look alike are totally fine. They never infringe performance rights. You may be running into different rights like image rights, personality rights, that sort of thing. But that's not a performance rights issue. And actually not all jurisdictions offer those rights. The UK is one of them, for example. It's a jurisdiction without personality rights, publicity rights, and a tiny little bit of protection coming from passing off, but that's it. So there is a gap there that AI taps into whenever it makes a synthetic performance, because an AI doesn't copy the recordings, it studies from it. And then the resulting output is a completely new data. It is not a remixing or a copy of very, very fine bits of the original recordings. It's just lifting the performance out of different data points and is able to regenerate it, generalize it into a new output. So it is a copy of the performance, like sound alike and look alike do, but it's a digital version of that. That can be done on scale in ways that we've never had before. Now, is that a problem? Yeah, I would say yes, it is. It is a problem, also exciting, but also a bit of a problem because of the gap in law that we have. So AI systems will develop. I mean, we're kind of sure of that. We don't know how yet. We have an idea, but we can see it's going there. So there'll be a rising growth of performance synthesization, and it will apply to you, it will apply to me, it will apply to performers, whether they're amateurs and professionals, and that will impact the performers' economic and moral interests, but also the interests of those that are investing in the making of those performances or in the careers of those performers. And what I don't want to do is to add to like the fear mongering and say, oh, that's going to be a threat, that's going to be a threat, that's going to be a threat. Actually, IP is quite good at seeing things in a spectrum of actually some good can come of it. There can be innovation, there can be an opportunity for new markets, new services, quite a lot of new applications that will help those people. But as long as we give them the tools and the protection to harness that innovation in their interest, or at least so that their labor is not completely left out and sort of free ridden upon. So AI will only be an opportunity for creative sectors and generally our commercial sectors or economy if we improve and adapt the intellectual property framework. And as I argue, is that it needs to look at performance rights for the part that regards performance synthesization. So that performance rights will need to be reformed. So in a way, we'll have a solution to that, and that's not complicated to achieve. And so my response to the UK Intellectual Property Office on this topic was to reform performance rights and to improve performance rights in order that reproduction of performances, as well as reproduction of the recordings themselves, at least be covered in a context of AI performance synthesization. And I did make some more audacious and inflammatory suggestions, such as perhaps aligning copyright and performance rights in one big regime instead of having a constellation of rights and neighboring rights there. If you want to read more, because I think I'm coming up to my sort of time, I've kind of detailed that in the context of UK law. It applies across the board generally, but I do think, you know, the reform will be needed. And before I go, I will put in one note, depending on whether I've convinced you on this or not, is that actually that kind of reform and change in technology happened before. Technology changed in the past, and that's exactly those changes in technology that created a need for performance rights. And that technology was sound recording, and then it was film. So it's sound recording and then films that force the need at national level and international level to create performance rights. And what I argue is that actually artificial intelligence is just the latest milestone in performance rights and in the history of performance rights that will just require a reform, either a top up of the right or a complete merge with copyright, depending on how audacious and how forward looking we want to be with this. And so AI is just another development in that technology. There's no need to be scared of it. It just needs to be talked about, discussed, and responded to. So merci. And that was a bit fast. I'm from Paris. You probably will have sensed that in the speed of which I speak. But yeah, thank you so much. And I'm glad internet held for that long.
Thank you very much, Matilde. I know about your internet issues, and I kept all the time the fingers crossed. Yeah, and it seems that we were lucky. I want us to reiterate the main thing that we've learned from your presentation is deepfakes, which is synthetic performances produced by AI, which do play an important role in the technology that plays an important role in this synthetic performances. You mentioned about the fact that the process of synthetic performances is new. I mean, at least from IP standpoint. And you mentioned about performance rights that do cover fixation of performances, reproduction and use of recordings, but not reproduction of performances. You mentioned about the fact that artificial intelligence will impact performances, economic and moral interests, and that those invested in making those performances. You mentioned also the need of the reform, and the last note was focusing of that the reform occurred when technology changed. So we're hopeful that for this time the reform will come up as soon as we expect. Thank you very much, Matilde, for your great presentation. It was really new for me, and I do believe that was really insightful for the others. I was just wondering whether we do have some questions. No questions in the chat, but I was wondering if someone has questions and wants to address directly to Matilde. So if there are no questions, thank you very much, Matilde. I just before leaving for the coffee break, yeah, I just want to very brief few messages how we are gonna organize ourselves after the break. So we are splitting into 3 panels. Yeah, if you are you were into the Dr. Heinemann presentation, so you are welcome for the first panel, which is dedicated to competition, intellectual property, and economic growth interferences and challenges. So I will keep this video conference open. So those that do want to attend the panel number 1, so you can stay in here. Then we have the second panel. If you really liked the presentation of Matilde related to copyright, performances, creative industries, so you are welcome to attend the second panel, which would be moderated by my colleague Natalia Mogo. And you have in the program the link and all the connection details, how to get access to that video meeting for the panel 2. And if you were really into the presentation of Professor Penin, so you are welcome to panel number 3, dedicated to European integration and intellectual property protection, which is a panel moderated by my colleagues Dorin Chimil and Olesa Plotnik. And you please look into the program for the links and connection details. So the first panel will be moderated by me, so I'll keep this video conference open. So everyone that wants to join us in the panel number 1, you are welcome. Meanwhile, I want to thank you to our speakers in the plenary session. I'm really grateful for your time and for your contribution to the success of this session. I do appreciate a lot of your efforts, and thank you very much for your time and your effort and commitment. Thank you. So now we do have a break, a coffee break. It's so pity that we cannot meet in person and drink and do networking and exchange experience during a real coffee break. But we do encourage you to take to reap the benefit of this break. But we are waiting you all at 1 p.m. Yeah. Please choose those that panel that you are interested in, and we are all waiting for the parallel sessions. Thank you so much.